Hi everyone, good evening. I hope everyone is well and keeping warm. The cold weather is definitely starting to set in. So thank you all for joining us for the final installment of our 2025 GP webinar series. So this evening we're going to be looking at involuntary admissions under the Mental Health Act. So we're joined by Dr. Sarah O'Dwyer, consultant psychiatrist, and Margaret Nicholl, Mental Health Act administrator here in St. Patrick's Mental Health Services. And over the course of the next hour, Sarah and Margaret will be presenting on the legal framework and practical steps for GPs associated with involuntary admissions. ICGP CPD certificates will automatically be sent within the next 4 weeks to any GP who is registered and is attending the webinar live this evening. Following the presentation from Dr. O'Dwyer and Margaret, we will have an opportunity for Q&A. So if you have any questions as we go through or going through the webinar, you can just pop them into the Q&A or chat box, which you'll see at the end of your screens, and then we'll try and get through as many of those as we can after the presentation. So that's it for me for the housekeeping, and we'll get started. I'll hand you over to Sarah and Margaret. Welcome to you both, and thanks for your time this evening.
So good evening, everyone, and I'm delighted that you could all be here this evening. So the hope really is that this will be a very informative evening and will address any queries that you might have in relation to Irish Mental Health Act legislation. So as the introduction says, my name is Sarah O'Dwyer. I'm a consultant general adult and old age psychiatrist, and I look after the special care unit, which is the locked unit here in St. Patrick's. And as a result of that, I care for the majority of detained patients here in the hospital. So I attend about 40 to 50 mental health tribunals a year, and I work very closely with my colleagues in the Clinical Governance Committee. And I'm delighted tonight that Mags Nichols is here with me, who's a senior member in the Clinical Governance Department as well. And that department really has oversight of all of the legislation and the regulations in relation to the mental health paperwork that comes to the hospital. And Mags has an eagle eye for detecting any errors or flaws in the paperwork to ensure really that the standards are met. And the aim really of tonight is to highlight why that is so important, because it can create significant obstacles and difficulties for the patient, as well as families, as well as the treating team, if the Mental Health Act paperwork is found to be deficit at a mental health tribunal. So just really to provide an overview, I thought it would be helpful to look really at the origins and put into context how we have our current Irish Mental Health Act legislation and the legal framework that's currently in place in this country, which is the 2001 Act. The aim then is to specifically look at recent developments in case law. And the reason for that is that they very much influence the clinical and administrative landscape of how we manage involuntary detentions, particularly as a result of case law that would have been developed in the last 12 months or so. And I'll speak and explain a little bit about that, and hopefully that will help to create clarity around the threshold that's needed when involuntary forms are being submitted to a hospital or an approved centre. Mags then is going to discuss the actual statutory forms, so the ones that GPs would be most familiar with, which is forms 1 to 5, how to complete them correctly, highlight the concerns that can arise if they're not completed correctly, and then also touch on the procedural timelines and the legal deadlines involved in the admission process as well. I'm then going to really take you through the journey from the time you complete the admission order to when a patient is admitted to hospital to the time that they sit a mental health tribunal within 21 days of their admission. And then I'll speak a little about the journey in hospital until that point and the challenges that can arise, and then also how the future landscape of how psychiatry is practiced in this country is very much going to be influenced by new legislation, including the new Assisted Decision-Making Capacity Act and the new Mental Health Bill 2024, which is currently in the pipeline and is very much going to change and impact on the current Mental Health Act 2001 that we utilise at the moment. So to begin with, I thought it would be helpful to just look at the origins and really, I suppose, some ways the dark history that Ireland holds in relation to the treatment of psychiatric patients. At a time really in the 1800s where custodial treatment and institutionalization was the focus of how psychiatric patients were managed. So the first mental health legislation in Ireland was the Lunacy Act, which was in 1821, and that was developed at a time when Ireland Ireland was still part of the UK. And this allowed for the establishment, really, for the subsequent 50 years of these very large asylums that were established all over the country. They were state-run asylums, and the focus really of care was institutionalization and custodial care. There was really significant deficits in any human rights approach. There was no advocacy, and there was no focus on the actual care or holistic care of patients. The most, I suppose, famous asylum was also known as St. Brendan's Hospital, was known as the Richmond Lunatic Asylum, which was established in 1815, and that ran for 200 years and only was closed in 2013 with the establishment of the Phoenix Care Centre, which is now on the old Grange Gorman site. And that really was symbolic of an end of institutionalized care in Ireland. And the difficulty at that time is that the number of patients who would have been admitted to asylums in Ireland was really quite stark, considering that Ireland is such a small country. In the early 1900s, we had the highest rate globally of patients that were admitted to institutions. And this was for lifelong admission, essentially incarceration. There was a time in the early 1900s when there was over 20,000 people incarcerated in asylums in Ireland, and that's in contrast to, on average, less than 2,000 patients that on any given night in Ireland would now be an inpatient in a psychiatric unit, and less than 5% of them would be involuntarily detained. So there was a move then in the early 1900s with the new act, which was the 1945 Act. And that did lead to significant change in the way in which we treat psychiatric patients. First and foremost, the term lunatic became null and void, and the term psychiatric patient was used, and the term asylum was eliminated and removed from the Act, and the term psychiatric hospital was removed. But the focus on institutionalization and custodial care was to the fore. And while there was certainly advances in the concept of a voluntary or temporary patient was introduced, so a patient could now be admitted to hospital and to have the opportunity to actually leave after treatment, which was a removal from the Lunatics Act, there still was a focus on institutionalization. And also to take into consideration that this act was still valid up until 2006. Now, the new act that we currently use, which is the 2001 Act, really that came about, and the key drivers of that was international pressure to really align with the UN Convention of Human Rights, and to focus really on holistic care with multidisciplinary team engagement, where the focus and the underlying principles should be about advocacy, safeguarding patients' rights, and the right to treatment, essentially, rather than custodial care. But the new act was not enacted fully until 2006, less than 20 years ago. And the reason for that is that it took 5 years for the Mental Health Commission to be formally established. Once that was established, the new act was fully enacted. And that is the act that we currently work with today. Although there has been case law and a number of amendments over the years. And as I said, there's a new mental health bill, which is currently in the pipeline. However, it's likely to be a number of years before that is fully enacted as well. So then to focus on the current legislation, which is the Mental Health Act 2001. As I said, the key changes with this act that varied from the 1945 Act was the introduction really of very stringent safeguarding of individual rights. So the introduction of mental health tribunals, which are an independent overview and assessment of every involuntary detention that occurs within 24 hours of, or 24 days or 21 days of any patient being admitted to an approved centre. There was establishment, as I said, in 2006 of the Mental Health Commission, which is an independent body that promotes very high standards and oversees basically the running of all approved centres in the country to ensure that certain standards are adhered to, and essential that the patient's rights are safeguarded. There was far clearer definitions about what a mental disorder was, and very strict and narrow criteria in relation to the involuntary admission of a patient who was suffering from a mental disorder. There was the introduction of far more transparent patient advocacy, so the introduction of independent legal representation. So this is solicitors that are basically appointed to every detained patient who is admitted to an approved centre, and they provide support and advocacy, and also at the Mental Health Tribunal. And also to ensure that there's certain clinical standards that are met, and these are regularly reviewed, at least on an annual basis, by the Inspector of the Mental Health Services. And really, very importantly and pivotal to change is the concept of voluntary versus involuntary, and the status and the legal status associated with being a voluntary patient versus an involuntary patient. That, of course, was introduced to some extent in the 1945 Act, but this Act clearly establishes the threshold and the legal standing of a voluntary patient versus an involuntary patient. So this is the Act that I work with on a daily basis, and Mags does also, given the fact that I look after the majority of detained patients. And as I said, in the last 12 months or so, there has been significant case law that has very much influenced how we now practice, and has really, I suppose, impacted on the standards that need to be achieved in order to ensure that if a patient is severely unwell and does require ongoing admission to hospital, that their order is affirmed at their tribunal. So I wanted to specifically talk about a case, I'm unsure of whether it's well known in primary care, but it's the case of AA against the clinical director of the Ashling Centre. So the Ashling Centre is the approved centre in Beaumont Hospital. Now this case went to the High Court in early 2005 and eventually went to the Court of Appeal in this year also. So to give you a background and understanding, and then why this case was so significant. Miss A, anonymised, was a lady with history of schizoaffective disorder, and she was brought to the emergency department in Beaumont Hospital by her husband due to what was recorded as bizarre and paranoid behaviour. So a nurse there in the emergency department completed Form 4. So that's an application under Section 9, which Mags is going to talk you through. And she noted in the section that helps to describe a mental disorder that a husband brought patient to ED, bizarre behaviour, paranoid, observed to be paranoid and psychotic in the emergency department. An ED doctor then saw the patient and completed the Form 5, which is the recommendation that the majority of GPs would complete, and that's under Section 10 of the Act, and stated in that, under the definition of what a mental disorder is, presented with irrational and paranoid thoughts, evidence of psychosis and a background of schizoaffective disorder. And then Miss A was transferred to an approved centre, which was the Ashling Centre in Beaumont Hospital. And there, her treating consultant psychiatrist completed the admission order, which is a Form 6, and that's under Section 14 of the Act. And in the box where you describe the mental disorder that the patient is suffering from, that consultant documented grandiose and paranoid delusional beliefs, lacks insight into need for treatment. So Miss A, with support of her legal representative, took her detention essentially to the High Court under Article 40, which is a habeas corpus hearing. And habeas corpus is basically a fundamental legal principle in the Irish Constitution that prevents unlawful detention of an individual in this country. And patients who are detained under the Mental Health Act have the right and ability to do that and to challenge their detention if it's deemed to be unlawful. So the High Court ordered that Miss A be released, citing insufficient detail on the statutory forms. So the Ashling Centre did appeal this, but at that stage, Miss A had already been released. But the Court of Appeal did hear the case because it was very significant and a huge shift in how we complete statutory forms. So in the case of public interest. So the conclusion of this case, which has run through the last year and has caused a significant change in the landscape of what we do, when this initially, this finding was concluded by the High Court, it led really to a huge number of revocations of admission orders throughout the country of very, very ill patients on the basis that they may have fulfilled criteria for mental disorder, but that the paperwork wasn't sufficient to prove that. And it caused significant distress for families and a lot of obstacles for approved centres who were attempting to provide care to patients that were very unwell. So the conclusion is that the statutory forms must contain a very clear and reasoned explanation as to why a patient meets criteria for mental disorder under Section 3 of the Act, and Mags is going to talk through that in detail. And that the absence of clinical reasoning or specific examples of the behaviour undermines the legality really of a patient's detention. So in many ways, in recent months, we've had many GPs make contact, I suppose, often very frustrated in relation to Mental Health Act paperwork being returned and being informed that it doesn't meet certain criteria. But this is the reason why there is a certain standard that now needs to be achieved, that wasn't as stringent in the past, and without reaching that criteria, mental health tribunals can automatically be revoked, which obviously can cause significant fallout for both patients and for families. So Mags at this point now is going to actually talk through the statutory forms and talk through the procedural timelines and the legal deadlines in relation to completing the forms, and talk through some of the pitfalls that can arise in relation to completing some of the detail on the forms as well.
Thanks, Sarah. And thanks everybody for your participation. This is it's great to have such a great number registered for tonight. So I'm going to just run through some of the practicalities in relation to the Mental Health Act statutory forms. I'll touch a bit on the Mental Health Act itself, some of the definitions under the Mental Health Act, and then I'll show examples of some of the checks that we carry out in St. Patrick's to ensure that the forms fit the threshold and the criteria to get us through a mental health tribunal. So Sarah's going to manage the slides, so bear with me now if this goes skew ways, but we'll try our best. So first of all, I'm just going to touch on a few points from the Mental Health Act, some of the definitions under the Act to describe the criteria for an involuntary admission, and also who's entitled to make an application to a GP for a recommendation for involuntary admission. So firstly, I'll start off with the definition of a mental disorder. So a person can be involuntarily admitted to an approved centre if he or she is suffering from mental disorder. So a mental disorder is defined as a mental illness, a dementia, or an intellectual disability that where, because of the illness, the person is at significant risk of causing harm to themselves or to others, or failure to admit a person to a hospital, failure to provide treatment in a hospital would lead to a serious deterioration in their condition. So the admission to the hospital is necessary in order to alleviate the material extent of their condition. So moving on from there, sorry, Sarah. Okay, so who can apply for an involuntary admission? There's 4 categories of people who can apply for a voluntary admission. An involuntary admission, excuse me. So the most common applicants are spouses or relatives of a person. But there's also a category called an authorised officer. The guards also have rights under the Mental Health Act. And then there's a 4th category called any other person. So as I said, the most common applicants are spouse or relatives of the person concerned. And in those cases, they would fill out a Form 1, a Mental Health Act Form 1. I will go into more detail about the different categories, but before I do that, I just want to show you that there's also a list of disqualified persons who are not allowed to complete an application for a recommendation. So under the Mental Health Act, there's this quite general list, actually, when you read through it. I mean, it's quite specific from A to E, but then you come to point F. So any person under the age of 18, they're disqualified, and that's very clear. An authorised officer or a member of the guards who's a relative of the person or a spouse of the person. That's quite clear as well, if you are aware or if you know that that is the case. A member of the governing body or the hospital that the person is being recommended to, or any person who has any interest in that approved centre in respect to taking payments from that approved centre, and any registered medical practitioner who has an interest in an approved centre that the person has been recommended to be admitted to. So from A to E, it's quite difficult for approved centres because we may not be aware, or we wouldn't have the knowledge. We wouldn't know if the person who's making the application fits any of these boxes under the Mental Health Act. But you as the GP, you might know. You would definitely have far more information than us. You would know some of the family history. So if you are aware, then you need to know that that person does not have the right under the Mental Health Act to make the application. No, point F under the Mental Health Act is spouse, parent, grandparent, brother, sister, aunt, or anybody who's married or has a blood affinity to anybody within A to E. So again, that's very general. And certainly the approved centre would not know. We definitely would not have the information if it was a new patient to the approved centre, but you as the GP or your family practice might have a little bit more information. So it's worthwhile knowing that that exists and that's under the Mental Health Act. So if we move on from there then, I'm just going to run through the different types of the application forms and some of the practicalities around the checks that we have to do to make sure that we fit the criteria. So first of all, there's the Mental Health Act Form 1. Now, these are all available on the Mental Health Commission's website, and I would urge you to go to the website, download the form if you are completing a form. The forms have changed once or twice a year for the past 3 or 4 years. So the only place that you're going to be confident you have the current version of the form is on the Mental Health Commission's website. And if it is an obsolete version of the form that's completed and accepted by the approved centre, it won't make it through the tribunal process, unfortunately. So I would urge you to make sure that you do visit the Mental Health Commission's website if you're downloading forms. So back to the different types of forms. There's 4 different types of application forms, and they're numbered 1 to 4. The most commonly used one is Form 1, and that's an application from a relative or spouse. It's worthwhile noting that a spouse under the Mental Health Act does not include a person who's living separately or apart from the patient, or somebody where there's an application or an order has been made under Domestic Act 1996. So again, I put that point up there because the hospital that you're making the recommendation to would not have that knowledge if it's a new patient, but you in your primary care centre or your GP surgery, you will probably have that information. So to be aware that somebody who's under this criteria, they don't have the right to make an application under the Mental Health Act. Mental Health Act Form 2, this is an application form that can be made by an authorised officer, and an authorised officer is an employee of the HSE, and they're specific in this role because of their background. They will have had a mental health background, and they're appointed by the HSE and given the authority to be an authorised officer. An authorised officer can attend a person's home or dwelling, and they can assess a patient and make an application on behalf of a family, on behalf of a friend, on behalf of a concerned person. They can make the application for a recommendation for involuntary admission. In St. Patrick's, we don't receive applications from authorised officers very often because we're not a HSE approved centre. However, in saying that, if we do receive an application and a recommendation completed by an authorised officer, we will absolutely assess it. So if you are looking for contact details for authorised officers, their contact details will be maintained in your local CHO offices, or if you contact the approved centre of the local hospital in your area, in your cohort, the approved centre should be able to put you in contact with somebody who has access to a current authorised officer list. Okay, and we'll move on from there. Thanks, Sarah. So then we're down to Mental Health Act Forms 3A and 3B. So under the Mental Health Act, the guards have a right under a specific section of the Mental Health Act to make an application for a recommendation for involuntary admission. So the reason that there are 2 forms for Gardaí, and they're very detailed forms, they're quite large and they're very detailed. The reason for it is that the guards, when they are making an application for a recommendation, need to be very specific under what section of the Act they are making their application under. So under Section 9, a guard can make an application if they are of the opinion that involuntary admission is in the best interest of a person. And that's very straightforward. The guard will provide the same amount of information that somebody who's completing a Form 1 or a Form 2 will need to provide. The guard can provide that information as well. The guard has to be very specific in their form to state that they are making the application under Section 9 of the Mental Health Act. If they were to make an application under Section 12 of the Mental Health Act, they can do so if they believe that the person who they're making the application for is suffering from mental disorder, and because of that disorder, they're a significant risk to themselves or to others. In this case, the guards have the right to enter a dwelling to remove a person into custody for the purpose of an application for a recommendation for voluntary admission. So the Form 3B for this type of application is quite detailed, and it's extremely difficult for the guards because the guard has to provide an extremely detailed report to evidence that the person fit the criteria under Section 12 of the Mental Health Act. Thankfully, these types of applications, for us indeed anyway, they happen very rarely. But it is very important that if you, as the GP who's receiving the application from the guard, is receiving a Form 3 or 3A or a 3B, that you understand the differences in both, and you understand that if the threshold isn't met, especially on Form 3B, to evidence that the person was a serious risk to themselves or to others, then that application will not make it through the tribunal. And then lastly, there's a Form 4. So this is an application from any other person. So examples that we would receive into St. Patrick's are generally from nursing homes or from older person services in a general hospital. So a nurse manager, a nursing home manager could make an application for a person under their care for a recommendation for involuntary admission. Again, these happen very rarely, but they do happen. They would happen more often than a guard's application or an authorised officer's application. Okay, thank you. So this is just an application form 1. I'm not going to go through the 4 different types of application forms because the checks that we apply to the 4 application forms are generally the same thing. So this is what a Form 1 looks like, and this is the form that a family member or a spouse or relative would complete when they are making the application to the GP's office. So on the next slide then, if just click onto the next one, Sarah, thank you. Now you probably can't read this because it's very small, but we will provide these slides to you after the presentation. But these are the types of checks that we would complete on any application that comes through the hospital. So first and foremost, we would check the demographic information for the patient. We would check it against our own current clinical records. If we didn't have a history with the patient, we would check it against the referral information that was sent in from the GP to make sure the name, the date of birth, the address is accurate and it matches with the rest of the clinical record that we have. It sounds very minor, but unfortunately we have had situations where the wrong address, the wrong name, the wrong spelling of the name has been brought up and heavily scrutinized at tribunal and has caused a lot of grief. So we make sure where we can, if it's at all possible, we check the demographic information that's provided on the form. As well as that, I skipped one, the very top, you won't see it probably, but the very top yellow circle on it, that's the version of the form that is in use. So we would make sure that the version of the form that comes into us is the current version that's available on the Mental Health Commission's website. Next, then there's the detail that's provided by the applicant. So the applicant needs to provide their name, their contact number, their address. Again, as I said, if the applicant fits the disqualification criteria, we wouldn't be aware of that. So we do rely heavily on the GPs who are making the recommendations that if you are aware, that you would let us know, or at least you would discuss it with the family before the application is made. The applicant then has to give us a description of what they've observed with the patient. And their description, we're not expecting medical jargon. We're not expecting clinical information. We're expecting their views. So the person hasn't been taking a medication, that they're unkept, that they are delusional, that they're aggressive, they're violent, they're threatening, they're not managing at home, they're not coping at home, things like that. But we do need some kind of detail. We have received applications in the past where we've received one sentence. We would always send that back and say, no, can you please provide us with more information and a more detailed observation. So at least then when we're bringing this through the tribunal, then the tribunal panel won't have a difficulty with understanding where the applicant was coming from in the first place. Next, the applicant needs to give us a little bit of information about the circumstances that led to the involuntary application. So again, it can be something along the lines of the person was not managing at home, they are harming themselves at home, they're not taking their medication, they don't understand that they are ill at the moment, they are not accepting that they need treatment, they're not voluntarily offering themselves to a hospital for treatment. So we did, again, a little bit of detail there, but we're not looking for something clinical. We're not looking for medical jargon. We're looking for the family's perspective here. It's important to note that the applicant has to have observed the patient within 48 hours of completing the application. So that must be evident as well. And then on page 2 of the application, I can't really see it myself. There's a section on the application that's called refusals. So if the applicant is aware that an application had been previously provided to either that GP or another GP and the application has been refused, the applicant is obliged under the Mental Health Act to state that it was refused and give us a little bit of detail around that. Then the applicant will date and sign the form, and the application then is brought to the GP and the GP then is obliged to examine the patient. So if we move on from there, thanks, Sarah. So then we're down to the GP's recommendation. So this is called a Form 5. And under the Mental Health Act, a GP when a GP receives an application from an applicant, then they have to examine the patient within 24 hours of receiving the application. The GP must complete their examination in person. There is a definition of what an examination is under the Mental Health Act, and I have that in a couple of slides down the way. The recommendation then, when the GP is satisfied that the person is suffering from a mental disorder, or they are of the opinion that the person is suffering from a mental disorder, the GP then will submit the application and the recommendation and any other referral information, clinical information, to the approved centre for consideration. A copy of the recommendation needs to be provided to the person concerned, and then that recommendation will remain in force then for 7 days. Day one starting on the day that the recommendation is completed. So it's valid for 7 days. So that gives the approved centre a little bit of time to receive the referral, triage it, consider it, make their decision. And if you've ever dealt with any approved centre, there's probably going to be multiple iterations of forms, because errors will be identified and there'll be a lot of to and fro before we get it right, before it's accepted. Next slide. Thanks, Sarah. So this is what a Form 5 looks like. Now, again, I know there's a lot of information on this slide. You're not probably going to be able to read it, but we will provide it to you afterwards. But it's highlighting the different types of checks that we carry out on the recommendation that's provided to us. Sarah went into a little bit of detail around the AA case and the level of scrutiny that is applied to these forms during the tribunal sitting. So we have included here on this graphic just some pointers for GPs so they can follow the information, so they can provide the information that we need them to provide in order for the recommendation to be considered valid. So first of all, we'll always check the version of the form. Again, same thing, we'll check it against what the current version of the form is that's available on the Mental Health Commission's website. We'll check the demographic information, and we'll check the applicant's information against the application that's provided. We will make sure, or we will check at least to make sure that the application was provided to the GP at least for that the GP received the application and completed the recommendation within 24 hours of receiving the application. And then we come down to your opinion on the form, and I can't really see on the slide, but I think it's section 11 down here on the form, and there's these 3 boxes. So if we go back, if you think back to the definition of a mental disorder, a mental disorder is somebody who has a mental illness where because of their illness there is significant risk to themselves or to others, or that failure to admit the person would cause a serious deterioration to their mental illness, and without treatment we can't alleviate the condition. So you are asked to give your opinion here on the form of which part of the Mental Health Act or what criteria does the patient's mental disorder fit. So you're asked to tick one of 3 boxes, and only one of 3 boxes. So you're either going to select A, that the person's mental illness is there's a significant risk of harm for the person or for others, or that without hospitalization and treatment their condition is going to deteriorate. So when we receive the Form 5, if more than one box is ticked here, this is one main reason that we will send it back to GPs to say, unfortunately, we can't accept that. You have to be decisive. You have to tell us 1, 2, or 3. You can't select all 3. And then when, based on whatever selection you make in this section, on the next section, you have to give a description of your findings. So if you select A to say that the person's mental disorder it will cause a significant risk to themselves or to others, then we will look for that evidence in the description. And if you select the next criteria, B or C, then we will look for the evidence in your description. So we do have some bullet points here in our guidance to kind of lead you down the right path. So to make sure that if you were to give us the information under all of these points, that we would be satisfied that the form would reach the threshold then to be valid at the Mental Health Tribunal. I will say that this guidance, this information, this was created by St. Patrick's. This is not created by the Mental Health Commission. This is our own guidance that we can provide to our referring GPs, and we're happy to provide it. We're happy to give it to you, but it's not something that came from the Mental Health Commission. Then it's worth noting as well that when the GP signs the recommendation, that they have to sign it within 24 hours of the receipt of the application. So if you sign it outside of that time frame, we will have to send the recommendation back to you to clarify that or to correct that. And then if you move on down again, so these are just some of the important points. So the applicant must observe the patient within 48 hours of completing the application. So we will look for evidence of that. If there was a previous application, the applicant has to state that on their application form. We may not be aware of that. The approved centre may not be aware of that, but you as the GP might be aware of that. The GP must examine the patient within 24 hours of receiving the application. And under the Mental Health Act, the definition of an examination is a personal examination carried out by a registered medical practitioner or consultant psychiatrist. And you need to give evidence of the process of contact, the thought, the mood, the behaviour of the person concerned. The GP's recommendation is valid for 7 days, day 1 being the date that it's signed, and the GP submits the application, the recommendation, and the referral or any other clinical documentation to the approved centre for consideration. A copy of the recommendation needs to be provided to the patient, and then lastly, the original application and the original recommendation have to be provided to the hospital. So they can either come in with the patient or come in with, I don't know why Mulryan is in the middle of it there, that's a typo. The original application and recommendation can be brought into the hospital with the patient or by a member of the family or somebody who's supporting the patient, or if the assisted admissions team are used to transport the patient into the hospital, the assisted admissions team can bring the original forms in with them. And I hope I've covered everything, and that's my last slide. Thanks, Sarah.
Perfect. Thanks, Max. Okay. So moving on from that, I suppose I'm going to just take over from the next step, which is once you have submitted the application, the recommendation, the referral, and there's a plan in place for this patient who needs admission to hospital and they're very unwell, the admission process begins. And that really begins with us making contact with the assisted admission. So the assisted admissions is an independent service that is is psychiatric nurses that will go and to someone's home or to the location that the individual has been identified to be residing at, and they will escort the patient to the approved centre. They're highly trained, so they're basically in a position to manage or to navigate challenging circumstances, because understandably a lot of these patients don't want to necessarily come to hospital because they've compromised insight and capacity in relation to how unwell they are. So once they do come into the hospital, my role really is to determine whether a patient fulfills criteria for mental disorder. So I essentially have to do exactly what the GP does. So in many ways, when someone is admitted under a form on application form and a recommendations between form 1 and 5, the GP is essentially the first opinion and I'm essentially the second opinion. So I need to determine whether I agree with that opinion. And when a patient is brought and escorted to the service by the assisted admissions within 24 hours of admission, and usually I would aim to see them well before that on the day of admission, if time allows, to determine whether that they fill criteria for a mental disorder. And I fill in, essentially the form 5 is very, very similar to the form 6, which I complete. Again, as Mag said, some of the key issues that we see is discrepancies or errors in ticking the boxes. So a lot of GPs on the form 5, and sometimes it can happen in form 6, is tick 2 boxes in relation to are they fulfilling criteria under section 3, 1A or 1B, 1A being the risk criteria and B being the treatment criteria. Now, if it's both, then you tick the last box, but you only tick the last box, whereas otherwise you tick A or B. And then since the AA case, the Mental Health Commission have extended the size of this box. So the description of the person's mental disorder, this box is now much larger, and that's to allow for adequate information to ensure that the threshold is met, to allow you to provide adequate evidence that a patient fulfills criteria as per the definition and the criteria under the Act. So again, if someone, or if I, or as Mag said in a Form 1, if you're going to tick that a patient is an imminent risk to self or others, so the risk criteria, you have to ensure that that is reflected in the description of the mental disorder that you provide. So you have to very clearly document what the risks are, what the risk profile is, and what the risk would be if the patient wasn't admitted to hospital. I have to do exactly the same thing. And then if it's under criteria B, which is the treatment criteria, again, you need to state what the diagnosis is. That's what I have to do. I have to say that their insight and judgment is compromised and why. I need to confirm that this is the least restrictive environment in which treatment can be provided. I need to say what that treatment is. And I need to say that treatment is going to benefit the patient to a material extent, because otherwise what's the purpose of them being admitted to hospital? And that their risk profile is likely to escalate and their mental state is likely to deteriorate if they're not admitted to hospital. And then I sign the form off. So once I do that, the patient is then of involuntary status under the Mental Health Act within the hospital. So as I said, this is just briefly to explain what happens when someone comes in on a Form 1 to 5. When a Form 6, which is the admission order, is completed, I immediately provide the patient with what's known as a patient notification form. And on that, it's a summary document. And that document documents the name of the person who made the application, the name of the GP or the medical practitioner that signed the recommendation. And it also explains what the proposed treatment is. Now, that obviously could modify depending on the patient's progress through hospital, but it's a general overview of the treatment. So I would usually document nursing and medical care, multidisciplinary team interventions, medications, risk assessment. Sometimes for profoundly ill patients, it might be ECT treatment also. It's very important that we also document whether the patient has capacity to consent to a voluntary admission. So often patients will come in on forms, but when they arrive in, they actually agree to stay voluntarily. But I need to make a decision that they actually have capacity to do so, and that voluntariness is basically there. It does reflect their will and preference, and that they genuinely understand that what it means to be a voluntary status versus involuntary status. And then we usually engage with the next of kin with the patient's consent. So the second parallel, I suppose, pathway that a patient can navigate in relation to voluntary status is a patient who's admitted to hospital initially as a voluntary patient. However, during the journey through hospital, for whatever reason, they indicate a wish to leave. And if they're deemed to be too mentally ill to leave hospital, Section 23(1) of the Act can be initiated. And what that means is it's essentially a hold for 24 hours. And within that 24 hours, a consultant psychiatrist needs to come assess the patient and to determine whether they do fulfill criteria for mental disorder as defined by the Act. And if that is the case, well, then we progress with a different admission order, different from a Form 6. It's called a Form 13, and that is signed. But in this case, again, a second opinion. So with the Form 6, essentially the GP to the Form 5, that's the first opinion. I would do the second opinion. In this scenario, because I'm the first person doing the form, filling in the Form 13, we get an independent consultant psychiatrist who doesn't necessarily work in this hospital, is entirely independent, to come and assess the patient to determine if they agree. They sign then the second part of that form, and I sign off on the third part, which means the admission order is essentially completed. And that patient then transitions from being a voluntary status to involuntary status. So understandably, as I'm sure you can all appreciate, it can be very distressing for patients when they are admitted to hospital through an involuntary process. It can be very confronting when they're taken from their homes by assisted admissions team. It can often be very frightening. Similarly, when a patient is a voluntary status but is so unwell that they're deemed too unwell to leave hospital and they transition to involuntary status, they can be really angry, and understandably, because there's a loss of liberty and a sense of loss of autonomy. They can often be very confused about their status and can be, particularly if they're severely mentally ill, if they're psychotic, or if they're cognitively impaired. There's often, particularly in older adults, catastrophic thinking and fear around the concept of a mental health tribunal. For them, it's synonymous with court. Often they're concerned that they're going to be incarcerated or that they're going to court and have to face a judge. And a lot of reassurance is needed to ensure that we can make sure they're fully informed. Now, their legal representative plays a huge role in advocating for them too, but as the treating consultant, I would play a significant role. It's very important to me to reassure a patient and for them to understand that this is not a legal or a criminal process. This is basically an inquisitorial process, and the aim is to just ensure that we're acting in their best interests. They're often quite fearful about attending tribunals, but again, I would always encourage a patient to attend a tribunal if they're able to and it's in their best interests. And often they're very preoccupied about the forms that have been completed and the legality of these forms, and that's often patients who are psychotic or quite paranoid. So within 21 days of a patient being detained on an admission order, they have to have a mental health tribunal. So I have to attend that tribunal, and there's 6 people who attend that tribunal usually. So it's myself as the treating and responsible consultant psychiatrist, and my purpose there is to give evidence and to assist the tribunal in order to make a determination about whether an admission order should be affirmed, which means that the patient remains detained, or revoked, which means the patient no longer remains involuntary. And in certain circumstances, they can leave hospital and have a right to leave hospital if they choose to do so. The members of the tribunal consist of 3 individuals: a layperson who's trained to sit on the tribunals, an independent consultant psychiatrist not connected to the approved centre that the tribunal is being held in, and a chair who's invariably a barrister. So at these tribunals, there will then also be the legal representative for the patient, and the patient may choose to attend or may choose not to attend. It's 50-50. Some patients find it very overwhelming and choose not to attend, but their legal representative there is to advocate for them. So when I attend a tribunal, I have to give evidence, and the evidence really is about providing information of the background history, the patient's narrative, their story to date, their journey through hospital to date, the circumstances relating to their detention under the Act. And really the aim is to provide evidence regarding the patient continuing to fulfill criteria for detention under the Act now, but also at the time of admission that they absolutely fulfilled criteria, and therefore that the legality of the order is being upheld. And I often then provide information about the fact that there should be evidence of progress, because the purpose of admission is that admission to hospital is likely to ameliorate their condition to a material extent. So the tribunal want to see evidence that that's actually playing out in reality. So you would always clarify the diagnosis as defined and aligned with the definition from the Act. And I will always conclude by stating whether I believe that the patient criteria under section 3.1a or b, so that's the risk criteria, the treatment criteria, or whether it's both criteria, and then as of today that they continue, the day of the tribunal, that they continue to fill that criteria. I usually summarise what the proposed treatment care plan is and how it's likely to benefit the patient, and I always confirm that this is the least restrictive environment in which I can provide that care, and I will request in that case for the tribunal to affirm the order. Now, the next step then is question time. And this, I suppose, is why it's so important that the forms are correct. So questions can be posed to me by any member of the tribunal. As I said, this process is meant to be inquisitorial. The reality is that it's adversarial, and it can be very challenging at times to provide evidence and to navigate some of the very challenging questions. I've had questions in the past where solicitors have questioned the authenticity and the, I suppose, moral and ethical standing of GPs, you know, have alluded to the fact that GPs have signed forms and not seen patients. So it can be really challenging to manage all of this while trying to focus on the purpose of the tribunal, which is to ensure that the detention is legal. And that's the only role of the tribunal. So the aim is to respond to questions comprehensively, address any queries clearly, again, with the purpose of trying to support and assist the tribunal to make a decision. If any further details are queried, I will always attempt to clarify them. But remembering that the purpose of the tribunal is to determine the legality, their role is not to question the clinical care of the patient, and that's outside the scope. But sometimes some solicitors may attempt to bring that into the room. So it's important that we try to keep it on track. And if a patient is present, it's always essential really to be aware of that. And I'm always cognizant of the patient's presence and the importance of maintaining rapport with that patient, because when the tribunal leave, I still have to continue to care for that patient and ensure that our relationship hasn't been ruptured by any evidence that was given during the tribunal. So once that happens, there's two options. One is the tribunal will be affirmed, in which case the patient remains detained, and that order can be renewed for a further period of up to 3 months, or the tribunal may revoke the order. And as I said, the AA case led to a mass revocation of orders a number of months ago, based on essentially ministerial, paperwork deficit. So in some cases, chairs will go ahead with the tribunal, acknowledge that they're going to revoke the order based on paperwork errors, but continue with the tribunal to determine whether the patient does fulfill criteria of a mental disorder, but it's irrelevant because they'll still revoke the order. Some chairs are more stringent and they refuse to go ahead with the tribunal and they just revoke it immediately based on errors on the paperwork. Hence why it's really important, and we're trying to emphasize why it can be so challenging for us if the paperwork is incorrect. So hopefully you can understand why often multiple iterations of the paperwork is required. We're just trying to act in the patient's best interest. So I wanted to talk a little bit about moving forward then about the current Mental Health Act and changes. Just really, this is kind of the closing point in relation to how the landscape and how we practice psychiatry and the management of patients with mental health difficulties or compromised capacity is going to be managed moving forward in Ireland. So there's two, I suppose, significant legal frameworks. The first is the new Mental Health Act Bill of 2024. Now, this is still a work in progress, but the aim of this bill is to really align with the Assisted Decision-Making Capacity Act, and hence the plan to transition from the current 2001 Act. And the aim is really to give patients a greater say in their treatment, to introduce enhanced safeguards in relation to involuntary admissions and treatment, and will even give clearer and more stringent criteria about detention and the criteria for what a mental disorder is and involuntary detention. There'll be new criteria, as I said, for detention. Now there's a lot of, I suppose, pressure, and there's been a lot of I suppose, coverage of that in the social media in recent months due to a lot of, I suppose, of the varying opinions about the new criteria for detention. There will be mandatory reviews, and there's going to be greater legal oversight and the introduction of mental health review boards to replace actual tribunals. The bill also plans to remove the term mental disorder and introduce more inclusive language such as mental health difficulty or psychosocial disability. I may not necessarily agree with that. I think it prevents and removes the voice of the most vulnerable in our society who have a major mental illness, but that's for another day's talk. And then that is going to be very much aligned with the Assisted Decision-Making Capacity Act, and GPs may be familiar with that in relation to having to do capacity assessments, particularly for EPOAs, enduring power of attorneys, or potentially for wills. So the Assisted Decision-Making Capacity Act was enacted, well, only recently, but it was originally brought in 2015. And this act assumes that an individual has capacity unless proven otherwise, and the move is towards a functional capacity assessment. It's about basically ensuring that supports are in place, and this will be the case for psychiatric patients as well, and patients who are involuntarily detained, to allow them to have support agreements in place, such as co-decision makers, assistant decision makers, and for those that lack capacity, have decision-making representatives. As I said, in relation to wills and enduring power of attorneys, GPs are probably quite familiar with this and the certain threshold that needs to be met. And the key really is that the new bill aims to work in parallel with the Assisted Decision-Making Capacity Act. So the principles affecting capacity assessments are very much going to change moving forward, and it will impact on how we provide psychiatric care in this country. But as I said, that's in the pipeline and is yet to really be finalised. So that's it, and thank you very much. And if there's any questions, Mags and myself would be happy to attempt to answer them.
Thanks so much, Sarah and Margaret. That was really comprehensive. And again, I say this to all of our presenters, but so impressed at the timing. So we have 5 minutes to go for questions. If anyone does have any questions, you can pop them into the chat or the Q&A box there. I can see we have a comment and a question in, just acknowledging how difficult it is for families. And this person is just wondering if there's enough authorised officers in Ireland. So I don't know.
Yeah, so the answer to that is no, there isn't. And one of the major issues with the new mental health bill is that they're planning on removing any, so a spouse, guard, etc., are going to be removed as potential applicants, and that all applications will have to be made by authorised officers. But currently in the country, there is absolutely an inadequate number of authorised officers. And if this change is brought in, there simply won't be an adequate number, and it will lead to significant delays, particularly in areas of the country where there's less resources. There could be days and days where individuals are waiting for an authorised officer to come and assess a patient. So it's likely to be, in my opinion, quite dangerous. But thankfully, they're willing to review that now, from what I understand.
Great. And then we have another question in there. So can you explain involuntary admissions for eating disorders? Do you need a court order to treat that, or is that only in general hospitals?
Okay, so yeah. So this is a bit of a tricky one. So if a patient is being admitted for NG feeding to a medical hospital, previously the wardship would have covered that. So the new Assisted Decision-Making Capacity Act has replaced wardship. So when a patient was admitted medically to a medical hospital, is deemed to lack capacity secondary to their mental illness, which is an eating disorder, and from the effects of starvation on their brain, and they need NG feeding, which they're refusing and not able to provide capacity to accept. Before, an urgent wardship application was made to the High Court, and the President of the High Court would allow an individual to become a ward of court for a temporary period of time to allow that individual to be fed for the purposes of imminent risk to life and to save their life. So it's basically life-preserving interventions. When wardship was removed and replaced by the Assisted Decision-Making Capacity Act, there's this large lacune really in the Act that doesn't allow you now to do that. So what happens now is that essentially you go to court for a court order and under inherent jurisdiction. So inherent jurisdiction is a legal principle, or it's a principle that's only bestowed on the High Court in Ireland, that allows the court to essentially safeguard the rights, the life of an individual who's deemed to be at imminent risk. So you go to court, you get an inherent jurisdiction, which is essentially a court order. But to get that, you need to provide a very high threshold of detailed information as to why that individual will be deemed an imminent risk to themselves and a risk of death. And if the court order is granted, it's usually only for a period of probably maybe a week to 2 weeks, in which time it has to be reviewed. Now, it can be extended again and again, but the aim is obviously if an individual with an eating disorder is being NG fed with treatment, that their capacity may return, their insight may no longer be compromised, and the inherent jurisdiction would no longer be needed. That can't be used in a psychiatric setting because the Mental Health Act is used. But it would be tricky to detain a patient in a psychiatric hospital for treatment when the treatment they need is actually food, which is going to be NG feeding. So many times it's often safer for them to be admitted medically and for inherent jurisdiction and a court order to be used. I hope that makes sense.
Great, thanks, Sarah. I mean, very comprehensive, and as a layperson at all, it makes sense to me as well. So I'd imagine now for our GP audience that made sense. We have somebody wondering, how do you access the assisted admission team?
So, well, Mags, do you want to take this one, Mags?
Yeah, so under the Act, the approved centre, when the recommendation is accepted and admission is going to take place, under the Act, the approved centre can organise the admissions team. It's not left to the family or the GP to organise it. It's left to the approved centre who's receiving the patient to organise it.
So we will leave it there for this evening, and I just have a few bits of housekeeping to sign us off on. So when we sign off this evening's webinar, there'll be a link on your screen where you can share feedback. As always, we'd love to hear your thoughts. It helps us improve future events, inform future topics. So if you have any ideas or suggestions at all, please do let us know. I'm conscious as well that a lot of people who attend these webinars attend regularly, so the survey for you might be quite repetitive, so there's obviously no pressure. But if you do have anything to add, please do let us know. For anyone interested as well in any upcoming CPD opportunities, we have our annual Founders Day conference, which is taking place this year on the 29th of November. So it's an online conference, and we'll be exploring the theme of mental health in turbulent times. So we'll be looking at children and youth mental health, digital determinants of mental health, psychiatry in humanitarian emergencies, the climate crisis, covering a whole range of topics there. So if anybody's interested in attending, you can register by going to stpatricks.ie/events. And finally, as I mentioned at the start, CPD points from the ICGP are available to any GP attending live this evening, and we'll send those to you automatically within the next 4 weeks. A recording of the webinar will also be made available on our GP YouTube channel, so we can pop a link into the chat there. You'll get an email from us anyway after with all the relevant links and the PowerPoint. So that is it from us. Thank you again, Margaret and Sarah, for that really comprehensive presentation.
Thanks, everybody.
Thank
Bye,
you.
everyone.
Good night.